You're on.
We're on. Off you go, sir.
Okay. Well, I thought what I'd do is to start when I was a parish priest in Turville, down in Buckinghamshire, in 1995, where I refused to pay my poll tax. And I was delighted when this caused a great stir in Henley-on-Thames. And the result was they deducted it from my pay, but I had been working with a young father who had got the he got legal custody of the children, and he could not pay his poll tax. They had moved him out to Slough from High Wycombe because he was told when he was living with his parents that they were overcrowded. In order to keep them at the same school, and he drove back every day. So he was £1,200 worth in debt. And I put together a mean statement. I went to court with him, and the magistrates remitted, in other words, let him off £112 worth of council tax. And that struck me as being one person, and there must be hundreds out there, if not thousands. And so I started something called Zacchaeus 2000 Trust. And it's very easy to start a charitable trust. What you do is you nick somebody else's constitution, you change the names, you put your own objectives in it, and lo and behold, you have a charitable trust to get it registered. And we existed to help people who couldn't pay their rent, their council tax, and their fines. And the first thing we did was to get a contract with Wycombe Magistrates Court to be there on Wednesday mornings with people who couldn't pay their fines and help them fill in their means statement. And I discovered after I started doing this from a lawyer friend that what I was doing was legal. And it was actually called a Mackenzie friend, which you probably heard of, which means that if you're a litigant in person, if you are a litigant in person, you may have a friend with you in court who has no right to speak, but he can, with the permission of the judge and, of course, with your permission. If you don't want him to speak, he can't speak. But if so you and the judge give permission, then he may speak on your behalf. And that's what I did for Dexter Cook, and we wanted to do that for a lot more other people. So I retired to Tottenham, indeed, in 1999, in order to continue work with impoverished debtors, because that's where I wanted to be. And since then, we've got a staff in Zacchaeus 2000 Trust. We've got we've been doing over 2,500 cases a year, and they are all rent arrears, council tax arrears, fines, electricity bills, utility bill arrears, and everyone is stuck in the benefit system. They're tangled in the system, which you all know is a mess. I got very worried about the charity commissioner, who started jumping all over charities, and indeed the government started passing laws saying charities may not do this, may not do that. And I think poverty is too serious not to be allowed to say what actually needs to be said. So I withdrew myself from the Zacchaeus 2000 Trust, and I set up Taxpayers Against Poverty, which is not a charity. We can say and do exactly what we want to do. So we come to the Local Government Finance Act 2012, and you will know, I suspect, that abolished council tax benefit, and allowed the local authorities to make up their own benefit system called the Council Tax Support Scheme. So 259 out of 326 councils in England and Wales are taxing benefits. And I call it taxing benefit. It's not they didn't start by calling it that. They called it a council tax support scheme, and of course you had to pay 20%, which is what happened in Haringey. When I saw that Haringey Council was going to do this and was consulting only benefit claimants, and not consulting me, who wasn't a benefit claimant, and wanted very much to do something to stop benefit claimants being taxed, I've always taken the view that it is mad for central government to provide people with enough money for food, clothes, fuel, transport and other necessities, and for local government to come and take it away.
Yeah.
And not only come and take it away, but come and take it away and add £125 costs, and then send in the bailiffs, who can add a further £400. They add immediately £75 just for the privilege of being given the case by the local authority. If they make a visit, they add another £235, and if they come to get the furniture, they add another 110. So that's a massive hit on somebody who's on £73.10 a week adult unemployment benefit, paying the bedroom tax and paying the council tax, and then has it enforced against them. And that was the new situation which was going to arise in April 13. And I knew that wasn't going to work. I knew it was going to cause a great deal of misery because of years of working people who couldn't pay their council tax. And I rang up a friend of mine called Ian Wise, who's a barrister who, in poll tax days, overturned over 1,000 cases of unlawful imprisonment for not paying the poll tax. They were all vulnerable people. And they should never had to go through that procedure. And I said, look, this consultation is going completely berserk. It can't be right. Only to consult the people you're going to tax about taxing them, and not tax me, who are not going to be taxed, both council tax, as to whether or not I approve. And I discovered that it would only cost me 86 pence a week, on average throughout Haringey, for everyone who was on benefit, council tax benefit, to keep 100% council tax benefit and not have to pay 20%. Well, he agreed, and to cut this bit of the long story short, he took it all the way to the Supreme Court, and we won in the Supreme Court. And Haringey's consultation for charging people council tax was found to be unlawful. But what is very naughty about that is that they got no penalty for it. They got a completely unlawful consultation, but they didn't make them do it again. The councillors all went home and laughing all the way to the bank. And I think that's enormously unfair on the council tax people on their benefit who have to pay the council tax. So, to my delight, I was quoted extensively by the judges of the Supreme Court. And I just want to tell you what I had written to the leader of the council. I wrote to Claire Coburn in October 2012, saying, I write to oppose your proposals on the ground that 25,560 households who now pay no council tax will not be able to pay 20% or around £300 a year from April 13. Benefits are paid to our poorest fellow citizens to provide the necessities of life, and they are already inadequate. And then they went on, and then I finally wrote, I'm shocked that no alternative to hitting the fragile incomes of the poorest residents of Haringey was included in the recent consultation. And the judges then did us proud, I think, and I quote this as often as I can. The judges then said their income was already at a basic level, and the effect of Haringey's proposed scheme would be to reduce it even below that level, and thus, in all likelihood, to cause real hardship, while sparing its more prosperous residents from making any contribution to the shortfall in government funding. Because what government had done was to cut the central funding by 10%, and they dumped the lot on benefit claimants. And the benefit claimants who were already going to have housing benefit caps were going to have a bedroom tax, and were going to have the local housing allowance. So they were cutting housing benefit as well. And not to mention freezing all the increases on benefits. So that was the first round, one to us, but in the most unsatisfactory way. And because I was now refusing to pay my council tax, I was duly summoned to court. And when I arrived in court, I asked the magistrates, how do you arrive at £125 costs? And they refused to tell me. And I read out exactly what was going to happen to people who couldn't pay their council tax. I read out all the benefit changes to the magistrate so that they knew. I then had to make an appeal, and they refused to sort of let it through, and kept on making excuses. And then my son Roderick, who was an enormous help in these things, knew a barrister. He said, she's very upset by the government. You better speak to Helen. And so I spoke to Helen and said, look, I'm terribly worried about, I know how busy you are because she's a person who takes legal aid cases in the whole field of benefits. So if you say no, you can't do anything, you just say so. We'll get by somehow. And she was all for it. She absolutely went for it. And we went through the High Court with her support, and they decided, the court, the judge, one judge it was on this occasion, Mrs. Justice Andrews, and she said it was indefensible of the council and the magistrates not to tell me how they arrived at £125, and we won that case. And however, yet again, Haringey has got off scot-free. They've broken the law on 2 occasions, and nothing whatever has happened to the councillors. And it's the councillors' responsibility. It is not the staff's responsibility. The councils are responsible for policy. The staff are merely responsible for carrying it out. And I won't have the staff criticised in this situation. So I was still dissatisfied. The £125, was it too big, too small? What do we do about it? So there's a procedure which means that you can challenge the local authorities' accounts. So I duly objected to Haringey's 2013-14 accounts, which meant that Grant Thornton, who are the 7th largest international accountants in the world, they privatised the auditing of the local authorities' accounts in 2012, and they spread them out among 4 major international accountancy companies. KPMG and Grant Thornton are a couple of them. Deloitte is another one. I can't remember the 4th.
PricewaterhouseCoopers? PricewaterhouseCoopers?
Probably. But anyway, there we were, and so I duly sent in my complaint, particularly asking the Grant Thornton to take into account vulnerable people, take into account the vulnerability of the people who are going to have to pay these costs. And I got one of the snootiest letters back I've ever received from anybody, I think. Here we are. Yeah, this is from I also another thing I do is I don't name and shame the people in these local in the local authorities or in Grant Thornton. He replied on the 5th of May, we have no remit to opine on the impact of this policy on the well-being of those required to pay council tax. And that is the nub of where we are at the moment. That is the nub of why I am appealing to the appeal court the decision of the High Court that he was right, which that cannot be right. Something has gone terribly seriously wrong if all that matters is the arithmetic of an accountant when you're dealing with really very seriously vulnerable people who can't pay the tax. So this is the nub of where I'm fighting at the moment. And what is important here is that they are actually, I think, they must be wrong. So I'm not only raising this with the appeal court, whether the appeal court will hear it or not, we don't know. I'm also raising the issue in the magistrates' court, having refused to pay my council tax this year too. And there is governmental guidance, and I think it's awfully important that anyone who's going to help people who can't pay their council that actually knows this governmental guidance exists. To my horror, CAB have just produced an otherwise excellent report on what's happened to the council tax over the last 3 years, which I'll come back to later. They have not mentioned these three fundamental protections of vulnerable people. Now, I'm particularly anxious about these three fundamental protections of vulnerable people because I lobbied for them. And I got them by simply lobbying Parliament, and for them not to be exercised, not to be used, is enormously frustrating. So, so the first one we will talk about is the DCLG. The DCLG has guidance to local authorities on good practice in the collection of council tax arrears. It should be seen alongside, and it refers to the national standards for enforcement agents, which is where I came in and where I lobbied for it. I'll tell you how that happened. When my friend Ian Wise was overturning 1,000 cases of unlawful imprisonment, I got a parliamentary question asked, how many more than 1,000 were there? Because he's only one barrister. And the answer came back saying, we don't keep a record of imprisonments for non-payment of council tax or poll tax. It's not important putting people in prison who are poor and can't pay their tax. So I was then phoned by the then Lord Chancellor's Department, which is now the Ministry of Justice. And they said, how do you know there are 1,000? I said, well, I know there are 1,000 because I know the barrister who actually ran each case, and I'm going to come and see him with you. I get to see you with him. And they agreed to that. And I'd been speaking to the bailiff companies, saying, what do you do about vulnerable people? And they said, no, we've given up doing that because all the people we deal with are vulnerable. And I said, well, send me the procedure you stopped using. And they did. They sent it to me, and we took it to this meeting with the Lord Chancellor's Department. And blow me down if a year later it didn't appear as page 9 and 10 of the local government of the National Standards for Enforcement Agents, which has been renamed now to the Taking Control of Goods National Standards for Enforcement Agents. But what's hugely important about that, it is quoted in the DCLG guidance, but it actually names a procedure for when a bailiff turns up on your doorstep and finds there is a vulnerable person. The procedure is that they should go back to the creditor, the local authority, or the magistrate's court, because it can be a fine, it can be a council tax arrears. Or it can indeed be any bill that they're doing. If they hit and it lists the vulnerable people that one might consider to be, it's a discretionary, it's not a legal document, so it is discretionary. But it can be taken into account in judicial review and things like that. But the list is very, very helpful. The elderly, residents with a disability, the seriously ill, the recently bereaved, single-parent families, pregnant women, unemployed residents, and those who have obvious difficulty in understanding or speaking English. It's a fairly comprehensive list. I'm highly entertained at the moment because I've been told in an email, which I'm not going to respond to until I get to court, that I shouldn't be raising issues about vulnerable people because I'm not a vulnerable person. And I'm looking forward to telling them, but I'm 84. I'm elderly, and it says so here. Not only that, I'm insolvent. Didn't you know that they charged me £47,000 for losing that case in the Supreme Court? So I'm broke, and I'm vulnerable in every conceivable way. And so I'm not. But that's not my point. My point is, the point is that they should have considered vulnerable people when deciding on the level of the costs. They shouldn't have left it out altogether. So all that's going on. Now, there's one other important bit of information, which anyone who's going to help anyone else through these dreadful procedures is something called the Wednesday Principles. Now, hand up, who knows what the Wednesday Principles are? Very good. Go to the top of the class. But why should you know? Nobody does. But they are absolutely central to all administrative law. The story is, and it's a story you will understand why I particularly like, that there was a cinema company whose name I can never remember, who wanted to show films in Wednesbury and therefore needed a license for a cinema. And they were told by the Wednesbury Corporation, the Wednesbury Local Authority, that they could show films in Wednesbury providing they didn't show them to under 18-year-olds on Sundays. And that was thought to be unreasonable by the film company. So they went to the High Court. And the High Court decided that it was unreasonable, but very, very helpfully gave the definition of what the legal definition of unreasonableness, which now goes throughout every part of the system. Whether it's magistrates, local authorities, a judge, the Supreme Court, the High Court, the Appeal Court, the magistrate. It's absolutely fundamental part of British common law. And it means this, that if you're going to make any decision, you have to take into account relevant information, leave out irrelevant information, and be rational. And when I discovered this, it was a great joy to know that everyone has to be rational when they're dealing with these kind of situations. It's a marvellous bit of law. There are various other aspects, like if they've got procedures, they have to have gone through them. But that's the fundamental one is the Wednesday Principles. So, in my lobbying activities, during the passage of the Welfare Reform Bill, which became the dreaded Welfare Reform Act, I got an amendment tabled by Lord Ramsbottom, who it's not too difficult. It sounds wonderful and amazing, and how could you possibly do a thing like that? But he was in the same regiment as I was, and I'm old enough to have done national service, so I've known him for quite a long time, and I just picked up where we left off, as it were. And so he tabled the amendment, and that the government, in all these decisions under the Welfare Reform Act, should abide by the Wednesday Principles. And we arranged a seminar for Lord Freud, under Ramsbottom managed to arrange that, and I fixed the seminar. And we had human rights people, we had the CAB, we had the Case 2000 Trust, we had all people telling Freud this was going to be messy. He produced a statement in Hansard, which is the best he could do. They wouldn't pass the law, it's already in the law, they said. But the point about that is that there is a judgment, a High Court or even the Supreme Court judgment, that if judges or magistrates are to take into account the intention of the law, what is the intention of the law, they can take into account anything that's quoted in Hansard. So what the minister has said is the intention of the law matters. So if you've got the the two guidance of the DCLG and the MOJ, you could now add the DWP. So all three of them are required to take into account the circumstances of vulnerable people. And I don't see why the accountant shouldn't take it into account as well. And in the end of the day, it is the council who is responsible for the level of the benefits, of the costs. They are responsible for £125. The auditor may audit, but he is not the person who makes the decision about the level, it's the council. And to my delight, as a result of these great efforts, they have reduced the costs. Council Haringey's costs are now £102 for a summons and £115 for a liability order, where it was £125 for both. Now, two final points. Well, three, if I may. I just wanted to go through the awfulness, you don't need to be told the awfulness of sanctions, but I was telling you about my original case, which was Dexter Cook, who really got me going on this because I'm so angry about what happened to him. This is a case of a man called John Smith, who is not real name, but he was sanctioned for 3 months. He had rent arrears, they went on enforcing them. He had council tax arrears, they went on enforcing them. If you're sanctioned for 3 months, you have no income. Therefore, the debts pile up over the 3 months, and you're still dealing with those debts for the next 3 months, 4 months, 6 months, year. So it's a devastating punishment. It's not just a 3-month punishment. It's a devastating punishment that hangs on and on and on and on. And I came in touch with this character, and he was talking to me and saying to us about whether or not he should throw himself off his balcony on the 5th floor of a council block. And so all these stories about suicide are happening, but they are actually only a tip of the iceberg, which I'll come into in a minute. He was then called on by the bailiffs at 7:30 in the morning. He called me at 8. I know the bailiff company. I rang the bailiff company and said, I'm going to take this case back to court. It was a fine he didn't even know he had for not having a TV licence. And the bailiffs were adding £400 to his £135 fine. And it's worth knowing that if you find anybody in that situation and they're obviously vulnerable, then you write to the magistrate's court and ask for them to rehear the case. And that's exactly what I did this time. I wrote to the magistrate's court, and down we went to the Highway Court, the magistrate's court, and as usual, we ran into trouble with the clerk. I warned John Smith. I said, John, if they won't let me speak, and they look at you and said, please speak, then you must look at them and say, I've asked the Reverend Paul Nicolson to speak for me. And he did his bit perfectly. And the counsel was saying, Mr. Nicolson, you're not allowed to speak here. And I was saying to the magistrate, yes, I am allowed to speak with your permission, which is perfectly true. And then the magistrate, in a rather testy way, said, please speak. So I spoke, and I gave him a statement, which was a written statement, showing how awful the whole thing had been. And the magistrate did what I knew he had the power to do, which remitted the £135 costs. Remitted the £135 fine and sent the bailiff away without their fees. So that's that point. 2 more points. I was saying to the Supreme Court, and the Supreme Court, to my intense delight, quoted me, that it was not going to be possible for people to pay this, and it was going to be very, very, very difficult for them. Well, it is now proving to be true. There is a Professor Danny Dorling. I suspect some of you have heard of him. He is one of the best professors I have ever met, and he sent me this letter because I'd written to him about something. It really is extraordinarily interesting. there was some new data which was due to be published by the Office of National Statistics on the 23rd of June, which, if you remember, was Brexit Day, when the voting was taking place. So this news has been buried by Brexit. It's never got out into the open. And he is saying clearly that there is evidence of a rapid decline in health across the United Kingdom since 2010. Well, frankly, who's surprised when you look at what's happening to people? And then there's a rapid rise in overall deaths in 2015. And he goes on to say, I can find no record of a previous Prime Minister being in power and having such a poor record, at least since 1940. This is rising ill health and mortality among the general population. Deaths due to a sanction are a small fraction of this rise. So that's one, I think, scandal. And the other is this, really, apart from the fact they don't deal with the procedures for vulnerable people, this excellent report from the CAB is saying two rather serious things. Council tax has now overtaken credit card debts as the major debt issue they are dealing with, which is quite something, really, because credit card debts have not gone down. And the other thing is that 58% of 1,200 cases in their sample were saying they were giving up eating or heating in order to pay council tax. So any predictions we could easily have made and did make about how bad it was going to be back in 2012 are now proving very sadly to be true. And finally, I went to, do you know that if I say I, Daniel Blake, does that ring any bells to you?
Yes.
Well, I went to a preview, and I was profoundly moved by it. It is a very, very accurate description of the way the benefit system drives people down into despair, which it does. And he's got it. He's got it beautifully. It is actually worse than he says, because he's only dealt with the Department of Work and Pensions. I know, and you know, that there's the local authority and the magistrates' court as well. And the cases that really hurt are the ones that have got three major government departments descending on one household, with all the power of government behind them and an impossible income, unable to pay a particular bill. And that's what really makes people ill and puts people under stress, unbearable stress. So that's coming out on the 23rd of October. It'll be at 100 cinemas then. And people, any of us could have been asked, I hope. We were asked in order to get people talking about it. So don't hesitate to talk about it. It's a wonderful scene where Daniel Blake scribbles all over the job centre. I, Daniel Blake, am not a number, I am a citizen. And we have to remember that all people who have been so appallingly treated by the state are citizens of that state and require and deserve human rights and just treatment.
Magnificent. You know, we'll have to do some.
So just have a quick
Slice
5 minutes
and a dice.
question. Is that okay?
Yeah.